Hello, everybody. Welcome to Truly Sinister. Today is Monday, December 1st. I can't believe it's Christmas already. Where'd the year go? It seems like the older you get, go the opposite way because you move slower, so time should go slower, I think, but apparently that's not how it works. I hope everybody had a wonderful Thanksgiving, and I hope you all didn't eat too much and make yourselves miserable. Excuse me. I had to work all weekend, and I worked last night, and that's why I didn't do anything earlier today. Is everybody watching the Brian Walsh trial? It's quite interesting to know what his defense is going to be. Apparently, she died of sudden adult death syndrome, which is a thing. I mean, it's a real thing. It's just very rare, and when you're listening to his first interview with the lead detective taking place at his home with the kids in the background and everything, you can already see, the wheels turning in his head. I mean, he was already setting it up for this type of defense. It looks, if he were to get caught, it seems like, because he was talking about how she hadn't been feeling well, and sorry, my nose itches, and she felt like she'd been pale and feeling under the weather, et cetera, et cetera. So it was like he was setting it up for that type of defense should he ever get caught, which, inevitably everybody gets caught. So it was just kind of interesting. It was a little slow, but I think we're just all used to the Kearney trials and the quick pace and drama, and it was almost like watching theater for the Karen Reed case. So if we compare every trial to that, we're going to be bored 99% of the time, I think. But if you just look at it in appreciation for what it is, I still enjoy it. But it's going to be interesting to see him try to pull this off. I find him less believable. I mean, he is innocent until proven guilty, but I think he's kind of narrowing his playing field by uh, adopting that cause of death. You know, because it. Why would you hide her body then? Why would you, you know, disassemble? I guess you could say her body if you found her unalive and it was totally innocent, you had nothing to do with it. Why most people wouldn't think that way. Most people would wake up and see their spouse laying next to them in bed unalive and call 911 out of panic more than anything. They wouldn't stop and Google how to disassemble the body. Anyway, the judge still hasn't decided whether or not she's going to allow the jury to know that he has pled guilty to those two other charges. I don't know when she's going to decide that, but they're going along as if she's not letting them address that just yet. She said she would have ruled on it today if either the Commonwealth or the defense was going to use it in their opening statements, but neither one of them had planned on using it in their opening statement, so she didn't uh, rule on it yet. So anyway, what I want to go over is Karen Reed's opposition. First, we're going to go over the Tully and the quote-unquote Mello affidavits in the Cosgrove response to Mark Bettero's mega motion, if you can even call it that. I think the guy's losing his mind. If you ask me, they need to do a competency checkup on him, because the whole response was kind of very unprofessional for one, and just he's off his rocker. He's losing it, and I think Turtle Boy's doing that to him. Not intentionally, but I think Turtle Boy's just too much for him, and he doesn't know what to do with him. So, a lot of sarcasm, a lot of immature, low jabs, digs at Mark Betterow and his writings, which obviously nobody agrees with because Mark Betterow is fan- fantastic at what he does, and it shows in his writings. But yeah, and he speaks for Mello in Mello's affidavit. That's why I put the Mello in quotes, because it's like, is it really Mello speaking? You kind of wonder. And when did he speak to Mello? And the whole thing about him missing the deadline. First, he had the extension. What was it? 3-week extension to respond to Mark Betterow's mega motion, and then they gave him a few extra days, and he not only misses it by a big margin, but he doesn't even let anybody know what's going on in the meantime. So I feel like the judge should just grant Turtle Boy's team the he should rule for Turtle Boy. I mean, he missed the deadline. He didn't keep anybody informed as to what he was doing and what was going on. I feel like he forfeits it. You don't give me your response, and the motion's granted, as far as I'm concerned. But that's not how things work in Massachusetts, as we all know. But yeah, it was kind of just a big fuck you to Turtle Boy's defense team and to Turtle Boy and to the whole justice system, as far as I'm concerned. I'm going to do what I want to do when I want to do it, and y'all are just going to have to wait on me. I don't. And that's how all the Commonwealth ADAs seem to behave in Massachusetts. I don't know if that's what they're trained to do or what, but they're all very disrespectful and inconsiderate of their fellow attorneys, meaning, the defense teams, and to the court and the judge itself. I mean, it's the taxpayers' money that's paying for these trials, and for the Commonwealth to just take that so lightly and, do what they want to do when they on their timeline is kind of bullshit, if you ask me. And somebody needs to hold them accountable for once. And if anybody's going to do that, I think it'll be Aidan Kearney's and his defense team. And so there's that. And then after that, I'm going to hopefully go over Karen Reed's opposition to the Commonwealth's request or motion for her phone data. That was put out a little bit ago, but I haven't really seen much of it, so I just thought it'd be interesting to go over. But before we go through all that, has anybody been watching Aidan Kearney's last few live streams? Pretty heavy stuff. I feel bad for what he's going through. You would never know. He's very professional, and he hides it very well, which has got to be not so good on your health, I would think. You would never know that he was going through the shit that he's going through. And I'm not going to even give her the satisfaction of saying her name, but she needs help. And, and I agree, we don't have the mental health available that we should in the U.S., and that's a terrible thing. But that doesn't give you the right to ruin people's lives. And it just seems like she has quite the history of doing this to her lovers or her boyfriends or whatever they are. And you can't keep using mental illness as an excuse. Eventually you have to take accountability and own it, and it just, and in some of it was crazy how in some of those recordings she actually sounded like LG. If you ask me, they had a lot of the same traits, it seems like. So I don't know how he keeps getting stuck with these women, but God bless him, and for him to say that he never wanted to do that, when people first started asking him about it, he would say, let me make it clear she didn't do anything wrong. I mean, how hard that would have been how hard that would be to say, knowing deep down inside what she's doing to you as you're saying that, and to say that and not just scream out, I don't mean that, that's a lie, this, I mean, he's a bigger person than I am because I don't know if I could do that. Um, but he's finally letting his feelings show, and that's healthy. He deserves to speak up on it and use his platform for telling his side because she's obviously blowing up X, and it's crazy. I didn't know somebody could write so much in one 24-hour period, but maybe that's cathartic for her. I don't know. But I wish him the best, and I hope he gets through this, and pray for him and his ex-wife and his kids that they aren't bothered by this anymore because, his ex-wife has absolutely nothing to do with any of it. Neither do his kids, and that the family's off limits. You want to go after Turtle Boy, fine, but the family is off limits, and that should be the case in any situation. Families should not be collateral damage. It's just not right, especially kids. So anyway, that being said, we wish you the best, Turtle Boy, and we are all here to support you. And you have the whole uh, true crime people behind you and supporting you in whatever you need. So let's get started, shall we? I was gonna do Aidan Kearney first, right? Okay. Is this? I have them all pulled up. I don't know which order they're in, so I have to make sure that I'm looking at them in the right order before I just start, going through them. Okay. So, let me get to page 1. Okay. Sorry. I don't know what I'm supposed to share, right? So, this is the affidavit of Lieutenant. You notice it doesn't say Lieutenant or Detective Lieutenant anymore. It just says Lieutenant, so I think he did lose his detective certification. Serves him right. Anyway, this is Detective Brian Tully's. What's going on here? Oh my gosh. Sorry, you guys. I don't know why I always have such an issue with this. Okay. Number 1, at the time of the initiation of the investigation of Aidan Kearney, also known as Turtle Boy, in May/June of 2023, for intimidation of witnesses in Commonwealth v. Karen Reed, I was the commanding officer of the Norfolk County District Attorney State Police Detective Unit. Just one second. I forgot to do something real fast. I'm sorry. So, just one second. Okay. Sorry. Let's try this again. Okay. My bad. Try to blow this up. Why is it not showing me? Not that I really care, but... Okay, it is what it is. Number 2. About 6 months into that investigation, in September of 2023, District Attorney Morrissey engaged Attorney Kenneth Mello as special prosecutor for Kearney matters. As obviously he was predicting Kearney to be an issue, right? Just one second, I'm trying to get my highlighter. Okay, we're going to change. Is it? Okay, yeah, that's right. Sorry, my bad. Okay. I have received what is captioned as an affidavit in support of motion submitted by attorney Mark A. Betterow, ostensibly in support of a motion to dismiss indictments pending against Kearney on various grounds, or in the alternative for an evidentiary hearing prefatory to any ruling on that motion. And I have also reviewed various materials submitted by Mr. Betterow in support of his motion. I submit this affidavit in opposition to the motion. In paragraph 29 of the Betterow affidavit, B.A., the defendant complains that the grand jury was never asked to return an indictment after receiving evidence of an illegal wiretapping of Stephen Scanlon, and suggests that the presentation of such evidence was part of a nefarious scheme to quote-unquote dirty up the defendant. It was in fact the intention to later present further testimony by Mr. Scanlon, but concern arose as to whether a Norfolk County grand jury had appropriate jurisdiction to bring that particular indictment, Mr. Scanlon having been in Suffolk County at the time. So further presentation was held in abeyance while that issue was considered. a situation that extended through the natural expiration of the then sitting grand jury. I don't like this layout, so let's go back to the other one. I just won't be able to use a highlighter, but that's okay. Number 6, the defendant raises various issues about my role in presentation to the grand jury of relevant video excerpts from his online presentations that were played for the grand jury. He edited them. I mean, there's no way to get around it. He retitled them. That's editing, right? He doesn't necessarily have to do anything to the actual video. He changed the title. That's an edit. With 2 exceptions, the Scanlon video and the quote-unquote before and after Gaetani videos, wherein the Commonwealth alleged that the defendant altered the original video to evade wiretapping charges. All of the video excerpts were found by me online. Right. As previously noted, the Scanlon video has not resulted in an indictment, and the relevant Gaetani indictment, I am told, was on or about October 22nd, 2025. Null prosecuted by the Norfolk District Attorney's Office. I don't know what that means. Some Latin term, probably. Anyway, so they're trying to put some distance between themselves and crusty pennies, it sounds like. Kate Peter is no longer needed. Mr. Mello is not electronically sophisticated. Wow, that's not very nice. And was not familiar with the audiovisual technology in the grand jury room, and therefore he tasked me with playing the video excerpts entered into evidence for the grand jury. I had operated that equipment during witness testimony on previous cases. Number 9, to facilitate my finding the correct videos at the appropriate time, I grouped them into electronic folders by alleged victim or topic, and I named the videos to accurately describe their content, often using the exact relevant phrases spoken by the defendant. So that's going to be his reason for changing the titles of the videos, not because what a douche. So it's still editing. It doesn't matter what reason you do it for, it's still editing. Number 10, in BA, paragraph 36, the defendant misleadingly represents that I, quote, apparently edited and renamed, end quote, various of the defendant's videos and falsely alleges that Special Prosecutor Mello and I used, quote unquote, this altered evidence to mislead the grand jury as to the defendant's intent. Well, he labeled the folder that he put them all in intent. So, I mean, the words came out of his mouth. I mean, that's the word he used, is intent. That's what they were all filed under in his computer. So, number 11. My alleged editing consisted of selecting relevant excerpts from the defendant's online presentations and presenting those excerpts in full. If one of Kearney's online presentations ran, for example, 2.5 hours and covered various topics, I chose the statement that the Commonwealth believed was relevant evidence. So he gets to choose what's relevant and what's not, apparently. He's the gatekeeper of that, it would seem. Number 12. As to the claim that the Commonwealth tried to mislead the grand jury as to his intent, I note that the Betterow affidavit makes no attempt whatsoever, in parentheses, much less an attempt supported by evidence, parents, to describe the defendant's actual intent. Number 13. The defendant was more candid in speaking to his online audience in describing his intent. Consider, for example, in an 8:30-2:23 presentation of Kearney's record of himself addressing people with a bullhorn and saying, quote, "We are trying to affect the jury pool. Yeah, that's exactly what I'm doing," end quote. I don't remember him ever saying that. 14. What was played for the grand jury were the defendant's exact words and the defendant's exact images. There was no attempt to mislead, and neither was there any need or desire to do so. Yeah, but you don't have to, you could have played the exact words and the exact images, but if you take them out of context, they mean something totally different. Like if you take something out just before, just after a certain set of words or a certain image, it could affect how it's perceived. It could, how it's taken. It could totally change what the meaning of that statement is. To the extent I may have mentioned the titles I assigned the video selections, it was to create a clear record as to which excerpt the grand jury was viewing at that particular time. And as noted, the titles I assigned were almost invariably taken from the words the defendant himself spoke in the relevant video. During the course of the investigation into Kearney's behavior, various individuals contacted myself, some of the Norfolk DA CPAC members, the special prosecutor, and others to complain about specific online presentations or other acts by the defendant. Well, yeah, remember Jennifer McCabe? Can't you make him stop blogging about me? To the judge. One such person was Catherine, quote-unquote, Kate Peter, a.k.a. Massholm or Krusty, whom I learned was a rival online personality who shared, yeah, you can call it a personality, who shared a mutual dislike with the defendant and from time to time would send me links to various of his presentations. Number 18. I was not aware of Ms. Peters' 2020 YouTube copyright dispute with Mr. Kearney or his alleged use in that dispute of a forged federal civil complaint described in the Bedrow Affidavit, paragraphs 119 through 125. I never viewed the November 20th, 2022 interview with Ms. Peters, BA paragraph 20, and neither did anyone bring it to my attention. That wasn't an issue, but it was thrown out because Kate Peter forged the copyright, the filing, the court documents before she sent YouTube a forgery, basically. I don't know how she didn't get prosecuted for that. I would think that would be illegal. And if not prosecuted, I don't know why YouTube didn't at least kick her off. I mean, like permanently, ban her permanently from YouTube if she's not going to be prosecuted. But I thought for sure that would be something illegal. Because they're always saying copyright, right? So if nothing's going to happen to you, then what's the threat about? Anyway. Similarly, I had no knowledge of Miss Peters planting a false story about Colin Albert as alleged in BA paragraph 131 through 144. Had I been aware of such a thing, I would have informed Special Prosecutor Mello. Would you have, though? Really? Not so sure about that. As to any person who contacted me and suggested that I should speak to some person who allegedly had information concerning criminal activity by Mr. Kearney, including Kate Peter, my response was the same. That person needs to call me directly. As to any person outside law enforcement agencies or the district attorney's office who sent me links to alleged online presentations by the defendant, including Kate Peter, having been extensively trained and retrained in cybersecurity and being aware that I was a potential access point to the office system, I made it a practice not to access such links. If the material as described seemed of possible interest, I would request information as to where it could be located online and then go to that source directly. Okay. In point of fact, when email arrives from outside the Commonwealth systems, it typically comes with the following warning automatically attached. And then it shows a caution. Warning. The suggestions that the investigation of Mr. Kearney was outsourced to Kate Peter and that the, quote, quote, the MSP told her several weeks before Mr. Kearney's arrest that they intended to arrest him on October 10th, 2023, end quote, BA paragraph 163 is unequivocally false. Kearney's arrest was in conjunction with the execution of a search warrant for electronic devices in his home and car. I was particularly concerned that there be no leak concerning the execution of that warrant, and the information was thus very closely held. Indeed, I understand from Mr. Mello that I did not inform him of the timing of the execution until the morning it was in progress. Well, why would you feel the need to... Why would you feel worried about there being a leak of the execution of the warrant unless you knew for sure that that wasn't what would happen? I mean, you don't hear most cops talking about the leak of a warrant being served when you watch different crime shows or court cases and stuff. I mean, I've never heard them mention that. While I no longer recall when I informed Mr. Mello, I have no reason to doubt his account. To buttress the fiction that Kate Peter had inside knowledge of the defendant's arrest, Attorney Betterow quotes from a radio transmission, quote, "Heard from KP, it was the same thing from yesterday. 2 older kids getting on around the same time, but it was 8:30, end quote. Then tells the court that, quote, on information and belief, KP referred to Miss Peter and she helped the MSP coordinate Mr. Kearney's arrest by monitoring him beforehand, end quote." And I still believe that. I mean, whatever. The current trend in law enforcement is to execute search warrants when the target is outside the residence, thereby reducing both the target's access to weapons and the possibility of evidence destruction, as well as increasing the safety of both the officers and the target. I did not want to conduct the search while the defendant's children were present, and I also did not want to arrest him in front of his children. Well, they were on the school bus, and you arrested him right outside the school bus, so I think that you failed at that then. Sergeant, what did it say? The current trend. Okay. Sergeant Keith Pantazellos was tasked, there's the KP, was tasked with monitoring the defendant prior to the execution of the warrant and informing us of when the defendant's children were safely on the bus. Sergeant Pantazellos was the KP referenced in the transmission Mr. Betterow proffers as evidence of Kate Peters' knowledge and involvement. About 6 hours elapsed between the defendant's arrest and his arraignment at Stoughton District Court. During his booking, the defendant was accorded his right to make a telephone call, which I believe he made to his mother. Possibly by means of his conversation with his mother or by other means, word of the defendant's arrest soon became public knowledge, and phone calls came in to the booking station asking about Kearney's status. When I arrived at Stoughton District Court, the halls and immediate area outside the courthouse appeared to be occupied by Kearney supporters, while the courtroom itself was occupied largely by supporters of Jennifer McCabe and the O'Keefe family. Well, there must be a leak then, because how did they know in enough time to beat everybody to court, right? So obviously, if they know, somebody told them, and it wasn't Aidan or Aidan's mom, because, come on now. I did not see Kate Peter in the courtroom, but after the hearing, she introduced herself to me in the hallway. The email communications from Kate Peter to me have been retrieved from the office computer system at Special Prosecutor Cosgrove's request, and I understand have been provided to the defense as discovery. I'm advised that the quote-unquote links in some of those emails no longer work, assuming that they once did. I've done nothing to alter the links, and neither have I accessed them or downloaded information from them. As to any online presentations, statements, or electronic communication by Mr. Kearney, my concern has always been to find and verify such information myself. Verify such information myself. I recognize no obligation or duty to click on every link in every unsolicited piece of information. In BA paragraph 184, the defense complains that it has not been provided with, quote, any response by D.L. Tully to Ms. Peters' question about files in a now dead Dropbox file, end quote. There was no response. In BA paragraph 186, Attorney Betterow offers an ostensible fact that, quote, according to D.L. Tully, they're still calling him D.L. Tully, and it's not D.L. anymore, it's just L. D.L. Tully, he relied upon information Miss Peter provided to him before he edited Mr. Kearney's YouTube episodes, end quote. Number 42. In support of BA paragraph 186, Attorney Betterow cites an affidavit of defense paralegal Courtney Healy, Defense Exhibit NN 43. Apart from any question as to the accuracy of Miss Healy's affidavit, I call the court's attention to the fact that it makes no mention of Miss Peter, and neither does it state that I, quote-unquote, edited any video. 44. Although at the end of the day, the important question is the accuracy of information presented to the grand jury, not how the information was gathered. I agree with Mr. Betterow's contention that the Commonwealth had no reason to, quote, consult with or seek Miss Peters' input on what evidence should be presented to the grand jury, end quote. BA paragraph 208. I did not do so. Okay. Did anybody else notice that at the beginning of that? Although at the end of the day, the important question is the accuracy of information presented to the grand jury and not how the information was gathered. Well, you can see that he truly believes that just by looking at the Karen Reed and the John O'Keefe murder investigation. They most definitely believed it in that investigation. Wow. Wow. Can't believe he said that. And they have that in writing. In identifying relevant videos, I relied in significant part on the feedback from victims as to which portions of Kearney's episodes had intimidating effect. Signed this 23rd of November, 2025, under the penalties of perjury. Lieutenant Brian Tully. Okay. Affidavit of Robert C. Cosgrove. Number 1, I, Robert C. Cosgrove, am a member of the Massachusetts Bar, so admitted in 1985 from 1987 to 2007. So admitted in 1985, sorry. From 1987 to 2007, I served in various capacities as an assistant district attorney in Norfolk County. From January 2007 into December 2021, I served as a justice of the Superior Court. The following year, I served in the same capacity as a recall judge, after which I fully retired. What's a recall judge? And now he's triple dipping in taxpayers' money. On or about March of 2024, I was asked by District Attorney Michael Morrissey to accept appointment as special prosecutor in connections with pending indictments against the defendant, Aidan Kearney. I agreed to meet with the district attorney and members of his staff to discuss the possibility. Attorney Kenneth Mello had earlier been retained as special prosecutor, and my task was envisioned as assisting him with legal analysis and motion work. After some discussion, I agreed to accept the position, having been assured that Attorney Mello, who was not at the meeting, would be pleased to have my assistance. A few weeks later, I attended a luncheon meeting in Bristol County consisting of Attorney Mello and about 7 other people, mostly officers, whom, with the exception of Lieutenant Tully, I had not previously met. As it turned out, that was my first and last face-to-face meeting with Attorney Mello in the course of the current proceedings. No, it's not, because you met with him to get his affidavit, didn't you? Number 4, redacted. I effectively assumed Attorney Mello's role by default. I have reviewed what is captioned as an, quote, affidavit in support of motion, end quote, submitted by Attorney Mark A. Betterow, billed as in support of a motion to dismiss indictments pending against Kearney on various grounds, or in the alternative for an evidentiary hearing. I have also reviewed a memorandum of law and certain exhibits submitted by Mr. Betterow. I submit this affidavit in support of the Commonwealth's memorandum of opposition to Kearney's filings. I begin by commenting on selected items in the Betterow affidavit. Hereafter, BA. I do not purport to be anything close to exhaustive, so failure to comment on anything averred by Mr. Betterow should not be taken as agreement, nor as preclusion of comment elsewhere or later. Number 7, BA, paragraph 73 states that, quote, Ms. McCabe and Ms. Roberts attempted to convince the DA that Kearney had access to Ms. Reed's defense filings before they were publicly filed, end quote. If so, I believe they were correct. BA, paragraph 83, marks one of many statements Mr. Betterow makes, quote, on information and belief, end quote. Here, as in other places, the phrase might be more accurately replaced with, quote, on pure speculation designed to benefit Mr. Kearney, end quote. Not so much. I don't think they mean the same thing. These just little digs, huh? BA, paragraph 95, sneers that, quote, D.A. Morrissey ludicrously decreed that Colin Albert did not commit murder, end quote. Quote, on information and belief, end quote, the Karen Reed trial judge apparently shared that ludicrous belief, prohibiting the defense from arguing that Colin Albert could have harmed O'Keefe in closing argument because of the total absence of evidence supporting such a theory. Because you wouldn't let them present any evidence in regards to that. Judge Kearney. At BA paragraph 108 and elsewhere, Mr. Betterow seems to advance the novel proposition that anyone subjected to criticism by a purported journalist, or perhaps anyone else, is thereby disqualified by conflict of interest from taking any action with respect to that person's intimidation of a witness. At BA paragraph 113, Mr. Betterow recycles previously made arguments concerning Mr. Mello's representations as to cell phones seized by Kearney. The relevant issues have been long since argued and decided, and are nothing more here than a quote-unquote make wait. Number 12, at BA paragraphs 52 through 59, as part of a discussion of issues relevant to the Reed case, but not to the case before this court, much less the issues in the present quote-unquote motion, Mr. Betterow mentions that Jennifer McCabe initially misidentified herself to the FBI and, quote, lied about, end quote, phone calls she made after the initial approach. My understanding is that Ms. McCabe was not convinced that the parties who showed up at her door claiming to be FBI agents were in fact such agents. Okay. And what changed between the time they showed up and the time they came back to convince her that they were agents, because she quit lying at that point. Putting that question aside, the court can take note that, quote unquote, Judge Betterow, describes McCabe's comments as, quote unquote, material lies to the FBI. BA paragraph 53. I observed that when the FBI believes someone has materially lied to them in connection with an investigation, that someone is typically charged. I'm not aware of any such charges being brought against Miss McCabe. Wow. He's just like taking dig after dig at Mark Betterow. How unprofessional is that? Relative to BA paragraph 116 to 197, I became aware over the course of many duties that Catherine, quote unquote, Kate Peter, was a former employee of Mr. Kearney's, that the two had a falling out and were now mutually hostile, that she, like Kearney, was an online personality, that she had apparently befriended certain Commonwealth witnesses, notably Lindsay Gattani, and that she had provided some information to the Commonwealth. Just I'm sorry, I'm gonna get a drink real fast. Just one second. Okay, sorry about that. Thirsty, thirsty, thirsty. What is it? Okay, why is this now all of a sudden so small? Keeps doing that. I don't understand why. Okay. Okay, so um, I have never met Kate Peter. I have never spoken to her on the phone, by email, or by any other means. Prompted by a demand letter of October 8th from Mr. Betterow, CBA, paragraph 277, on or about October 29th, 2024, I texted Mr. Mello in pertinent part requesting, quote, copies of any communications, end quote, with Kate Peters, but her last name's Peter. Redacted, on or about December 16th, Mr. Mello forwarded me the pertinent emails. My attention at that time was largely absorbed by issues involving setting up and effectuating a taint protocol, and that concern was immediately followed by the process of searching for and disassembling emails from the named victims and their associates. It was my thought to turn over those emails and the Peters emails more or less simultaneously. I concede that I did not get the Peters emails to the defense until July 2025. Although the delay is regrettable, it was always my intent to provide the information, and I do not believe the defense was prejudiced thereby an issue. Addressed more fully in the Commonwealth's Memorandum of Opposition. So basically, I don't think he was affected by it, so No harm, no foul. What are rules? After consultation, I decided that the most effective way of finding any emails sent by Miss Peter in Lieutenant Tully's possession, in parens, as well as certain other relevant emails, was to do a term search through the NDA computer system using a program identified to me as ETOS. That search, conducted by Office IT personnel, produced roughly 5,000 pages of documents which were transferred to my laptop. I reviewed each page, making electronic redactions, a process that took me about 20 working hours. Okay. Somehow I don't see him going through 5,000 pages himself. That's just me. Because term searches invariably generate quote-unquote false positives, in this sense of documents that may contain a search term, for example, quote-unquote Peter, when the Peter in the document might be Peter Graves, rather than the relevant Kate Peter. This occasioned a number of redactions. In one instance, there was email correspondence with a number of attachments relating to a convict purporting to have information on a murder, wholly unrelated to either the Karen Reed case or Kearney's. Tully replied to this email, generating a further back and forth, and the nature of such electronic communication meant that each email, irrelevant to Kearney's cases, was each time reduplicated, and thus each time required redaction. After I completed this process, I transferred all the pages of my redacted copy to a thumb drive, called up the document in the thumb drive, and concluded, based on my observations, that the transfer was successful. I delivered the thumb drive to the defense on July 7, 2025. Is that the one where they got like 4 pages and the other 4,000 pages were blank? Is that the one he's talking about? Sometime within a week, Mr. Betterow emailed me complaining, that the majority of the pages on the drive were blank. As explained below, this ostensible problem was quickly remedied, and any implication that the Commonwealth engaged in misrepresentation to the court is untrue. CBA paragraph 294. I immediately responded to Mr. Betterow's email, stated to him that obviously this was not intentional, and asked him to return the thumb drive so that I could ask Norfolk DA IT to examine it and see if they could determine the source of the problem. I added that I would have the IT department, rather than myself, do another transfer, and I would check to make sure all pages copied and provide the defense with a replacement thumb drive. Several weeks passed with no comment or response to my request for the original thumb drive, so I cannot speak with any personal knowledge as to the existence of blank pages, although I have no reason to doubt the veracity of what Mr. Betterow represented. You're goddamn right. He is probably the most non-corrupt person you could meet. So, yeah, you have no reason to think that he misrepresented his statement. I nevertheless followed through, replaced the thumb drive with a new one, verifiably containing all of the pages as acknowledged in passing in BA paragraph 296. If it is true that the Commonwealth, quote-unquote, never responded to the information Mr. Betterow characterizes in BA paragraph 286 as a, quote-unquote, request for evidence, that is likely because the Commonwealth already responded to what I regard as an essentially identical request from Mr. Bradle in my letter of May 8, 2024, i.e., quote, if there's data missing, end quote, if there's data missing, that is because it was missing when the phone came into the Commonwealth's possession, custody, and control, and thus we do not have it, end quote. Following service of the Betterow affidavit, I emailed a copy to Attorney Mello and asked him to review it. On or about October 15, 2025, we spoke on the telephone about that and other matters. As of today, Monday, November 24th, the Commonwealth's response is overdue, and Mr. Mello, through no fault of his own, has been unable to forward me his affidavit. Lacking that, the next best thing appears to me to be to report on representations I am confident he made during our conversation, which of course is of course hearsay, but one hopes quote unquote reliable hearsay, per Mr. Mello and per Mr. Mello, per Mr. Mello and adopting his voice for paragraph 26 through 58. Reliable hearsay. So can somebody say the next objection they get from the Commonwealth for hearsay? Can they argue, well, it's reliable hearsay, Your Honor? I mean, does it make a difference? Hearsay's hearsay, right? They should try it though, and then refer to this affidavit. It's acceptable in that. It's a legal document. Unbelievable. Attorney Betterow contends that Kenneth Mello used the first day of the grand jury proceedings to quote-unquote dirty up Kearney by introducing quote irrelevant and prejudicial evidence relating to an uncharged allegation, end quote, that he wiretapped Stephen Scanlon, a topic entirely unrelated to the witness intimidation allegations before the grand jury. It is true that on my first appearance before the grand jury, I presented in good faith evidence relevant to the defendant's wiretapping of Mr. Scanlon. Just one second. Okay. Now, where was I? Okay. It is true that on my first appearance before the grand jury, I presented in good faith evidence relevant to the defendant's wiretapping of Mr. Scanlon. I considered the case to be in the process of investigation and did not present an indictment at the conclusion of that day for the grand jury's consideration, intending to later present additional evidence. Shortly thereafter, a question arose as to whether a Norfolk grand jury had jurisdiction to indict on a wiretapping case where the alleged injured party to the conversation was in Suffolk County. For this reason, I did not press forward on indictment. I considered the possibility of seeking appointment as a special prosecutor in Suffolk County, which would, of course, have required my presenting the case to a Suffolk County grand jury, and put possibility aside, intending to research whether Kearney's actions could make out a complaint of intimidation of a witness, which under statute could proceed in Norfolk. Got an itch in my throat. I turned my immediate attention to charges that did not present a jurisdictional question. Fully occupied with those, I simply ran out of time to resolve the jurisdictional issue and make a further presentation to the then sitting grand jury. Attorney Betterow also suggests that I misled the grand jury by quote-unquote limiting evidence of Kearney's intent to quote D.L. Tully's edits of his episodes, end quote. I did quote-unquote limit the evidence of intent to what was relevant. Yeah, what you saw is relevant. Just one second. Itching my throat. Okay. I asked Detective Lieutenant Tully to prepare appropriate clips for the indictment and to play them for the grand jury. The titles he attached to the excerpts were, as I understand it, assigned to reflect the content and so enable Tully to find and access them efficiently when playing the video clips to the grand jury. The titles Tully used were almost uniformly drawn from Kearney's actual words, and Tully never represented that the titles of the clips, which were obviously excerpts selected by the Commonwealth from longer Kearney broadcasts, were titles assigned by Kearney. Well, why would you? I mean, obviously they're going to assume the titles were assigned by Kearney, right? I mean, you don't have to tell them that. It doesn't matter. It's still editing, no matter how you put it. It is true that Kate Peter provided certain information concerning Kearney to the Commonwealth. No shit. At that time, I was aware of her as a rival blogger of Kearney's who believed she had been ill-treated by him, a status which hardly made her unique. Wow, another little dig. It's weird how this part of the affidavit is supposed to be Mello talking, and yet the low blows and the sarcasm is the exact same as Cosgrove's. But yet it's two different people speaking. I don't buy it. But it's reliable hearsay. So don't forget that. I regarded Peter as a possible source of information, just as I regarded various others. She did not, in any sense, run, direct, or control the investigation into Kearney's activities. I had no knowledge of her. Well, they wouldn't have even known about half the shit that Aidan does if it weren't for Kate. So that's how we know that she is directing the investigation, because there's no way they would know half of this shit, because they don't watch him closely enough like she does to know all these little ins and outs of Aidan Kearney's life. So you can't convince me that she's not directing or controlling the investigation. I don't buy it. I had no knowledge of her federal civil suit against Kearney years earlier, and neither was I aware of her subsequent alleged role on May 28, 25, feeding Kearney false information with respect to Colin Albert as described in Mr. Bettero's affidavit. Yeah, I wonder what the Alberts thought about that. I wonder how they feel about her accusing Colin Albert of being a drug dealer. I did not follow Peter's social media presentations, and neither did I view each and every one of Kearney's numerous social media offerings. In fact, the most common means by which Kearney's behavior came to my and the MSP's attention was through complaints from alleged victims, which rendered much of the information provided by Miss Peter redundant. Yeah, okay. Miss Peter's primary contribution to the investigation was to provide contact information relative to Natalie Wywicki, Natalie the German, the early go-between for Kearney and Karen Reed. Natalie was then interviewed by the Commonwealth, and a recording of that interview was presented to the grand jury. Yeah, remember he flew all the way to California to interview her on the taxpayer's dime? For what? Peter's other primary contributions consist of 1, providing purported recordings by Kearney of a phone conversation with Scanlon, but as previously noted, the Commonwealth never procured an indictment based on that conduct, and 2, providing purported recordings of a conversation between Kearney and Lindsay Gaetani. But I am advised that the resulting indictment has been null proseed. I don't know what that means. The information as to the execution of the search warrant at Mr. Kearney's home was closely held by Detective Lieutenant Tully, who notified me on the same morning he intended to proceed. I was somewhat dismayed because I knew that Kearney's arrest would require me to get over from Fall River to his arraignment at Stoughton District Court. I dressed appropriately, well, that's good to know, gathered such papers as thought necessary, and called an investigator and asked him to drive me, which he did. I did not advise Kate Peter or anyone else of Mr. Kearney's pending arraignment. When I arrived at Stoughton District Court, I was sitting for a time in the lot with my investigator in his truck. A number of Kearney supporters were outside the courthouse. We were approached by a blogger named Thomas DeRoster, that's Tom CPU, who I believe has had an online presence as Tommy CPU, and whom I regarded as a supporter of Karen Reed and Kearney. DeRoster, is it DeRoster or DeRosler? DeRosler, or DeRossier, sorry, immediately began a conversation, but I noticed he was recording. I advised him that he did not have my permission to record and that he was violating the wiretap statute. He then left. The contention that, quote, outsourced investigative work, end quote, to Miss Peter, discussed strategy with her, and was aware that she edited Mr. Kearney's content with her own editorial slant and bias, is utterly false. Except as previously noted, I relied on Lieutenant Tully to independently locate each and every video excerpt introduced before the grand jury in Kearney's own internet presentations, all of which were introduced without modification. After the defense complained that certain links in some of the emails from Miss Peter to me provided in discovery were not active, Special Prosecutor Robert Cosgrove asked me to revisit these emails. Had asked me to revisit these emails I had forwarded him for that purpose and check to see whether those links could be accessed from my computer. I did, and they could not. They were deleted or set to self-destruct. Mr. Cosgrove also asked me to check to see if I had downloaded any of the material once theoretically accessible by link in the event that I might have a copy of such material on my hard drive. I checked, and I do not. To the best of my knowledge, understanding, recollection, and belief, any of the quote-unquote Peter links I may have chosen to and been able to access were to materials posted online by Mr. Kearney himself, and thus remain within the defendant's knowledge, custody, and control. Moreover, with the above noted exceptions consisting of a recording which ultimately did not ask the grand jury to return an indictment on, and a recording that generated an indictment but was dismissed by the Commonwealth as one of the Gaetani indictments, all of the recordings or excerpts thereof were obtained by D.L. Tully directly from the internet and have long since been provided to the defense by either myself, Lieutenant Tully, or Mr. Cosgrove. In the event that Mr. Mello is able to complete his affidavit and I secure it in time for consideration by this court, I reserve any right this court may afford me to move to strike paragraph 26 through 58 and submit that affidavit in their place. Sworn this 24th day of November 2025 under the pains and penalties of perjury. Alrighty. So there's that. Okay. So, just 1 second. I need to just say goodnight to somebody. I'll be right back. Okay. So, let me see. Now let's go on to the okay, so now let's go on to the Karen Reed opposition to having her phones confiscated, or her phone data. Um, okay, let's see if we can make this bigger. I don't have a highlighter for this one either. That sucks. It's not getting bigger. Okay, so let's try something else. Well, let me download. Open. Okay. Then let's try this. Where's it? Where did I put it? I mean, I have it on screen, but it's too small for me to read. So I saved it. Where did I put it? Just 1 second, please. I knew it was going too smoothly to be true. Is this it? Oh boy. That, okay, how do I? Mm, okay, well that didn't work either. So we're just gonna have to go off the one I have originally, which is, what did I do with it? Okay. Um, that's just one page though. Okay, so that didn't help either. Mm, I don't know if I'm able to read this. Mm-mm-mm. Okay, let me try one more thing. I have it on my phone, I believe, so let's see. Where is it? Sorry about this. Mm-mm-mm. My God. Mm. Okay, I think I found it. Now if I can figure out how to get it over to my desktop. Mm. Oh my gosh. Okay, I have one more option. Can't believe this. Okay. I figured it out. Yay. Thank the good Lord Jesus. How that so long? And here we go. Miss Reed's memorandum in opposition to Commonwealth's motion for examination of digital materials seized from Karen Reed pursuant to search warrant issued on January 22nd, 2024. Now comes Karen Reed, Miss Reed, a third party to this matter, and respectfully requests that this honorable court deny, in all caps, the Commonwealth's motion for examination of digital materials seized from Karen Reed pursuant to search warrant issued on January 22nd, 2024. The Commonwealth has no probable cause whatsoever to believe there is any new evidence of criminal activity contained within Miss Reed's cell phones, because any information that the Commonwealth might hope to glean from the requested records is duplicative of the information already contained in Mr. Kearney's cellular telephone records, which have been in the Commonwealth's possession since the start of this case. The Commonwealth, is this it? Wait a minute. This can't be it. Just one second. What the fuck? That's not the one I was looking for. Oh yeah, it is. It's just I'm gonna have to go from page to page independently, apparently. Wow. The Commonwealth has failed to allege particularized facts that any information contained in Miss Reed's cellular records, beyond information that is already in the Commonwealth's possession, is relevant in any way. The court should return Miss Reed's personal property immediately. Okay, so how did I get this one bigger? I had to open it in a separate tab each time, so I'm going to have to do that with each page, apparently. It's crazy. Come on. This one's not getting bigger for me. Okay, here we go. What a pain in the ass. Oh my god, I'm gonna have to do that after with each page, apparently. Okay. Would have been necessity, right? Miss Reed's phone, factual background. Miss Reed's phone was searched by the Massachusetts State Police pursuant to a search warrant issued on February 2nd, 2022. 4 months later, on June 9th, 2022, Miss Reed was arrested a second time for the same incident. On January 24th, 2024, Lieutenant John Fanning seized 2 more of Miss Reed's cell phones pursuant to a seizure warrant issued on the basis of quote-unquote witness intimidation, allegedly perpetrated by Miss Reed. On March 27th, 2024, unbeknownst to Miss Reed, the Commonwealth convened a grand jury to determine whether a true bill should issue requiring Miss Reed to stand trial for numerous counts of conspiring with Mr. Kearney to engage in witness intimidation and or harassment against Brian Albert, Colin Albert, Chris Albert, Jennifer McCabe, Matthew McCabe, and former trooper Michael Proctor. On the very same day, March 27, 2024, the grand jury concluded that there was insufficient evidence to find probable cause that Miss Reed committed the acts of intimidating or harassing the witnesses, officially rejecting the Commonwealth's allegations. And what is it they say? You can indict a ham sandwich? Apparently you can't. Apparently it's not that easy. On July 1, 2024, a mistrial was declared after the jury deadlocked. Miss Reed did not learn about the grand jury's rejection of her alleged involvement in witness intimidation until a notice of discovery produced by the Commonwealth on October 10, 2024, approximately 6 months later. On April 22, 2025, 1 year after the start of her first murder trial, Miss Reed was tried for second-degree murder, manslaughter, and leaving the scene. On June 18, 2025, the 3.5-year saga came to a just end when the jury acquitted Miss Reed of all charges related to John O'Keefe's death. After her acquittal, the Commonwealth remained in possession of Miss Reed's personal property. On July 28, 2025, Miss Reed... This is crazy that I have to do it this way. I gotta do this. I add each page time I do it. What a pain in the butt. Argument 1. Legal landscape and evidentiary standard. In Massachusetts, like many other states, prosecutors may, in certain circumstances, present identical evidence to a second grand jury after failing to obtain an indictment from a first grand jury. However, this power is not absolute. The purpose of indictment by grand jury is to shield the innocent against hasty, malicious, and oppressive public prosecutions. ID internal quotation omitted. Repeated submissions of identical evidence to successive grand juries, especially in light of harassing, malicious, and biased prosecution, poses a limitation on the prosecution's ability to resubmit evidence to a new grand jury. For example, when a governmental body has no legitimate or reasonable purpose for pursuing an indictment by a grand jury after repeated attempts, the court may inquire into the prosecution's stated purpose and prevent resubmission. Some courts have indicated that even in the absence of statutory limitations, the power to resubmit is not boundless nor immune from judicial control. change this again. God damn it. What a pain this is going to be. Hope it's not very long. In Commonwealth versus McCravey, the Massachusetts Supreme Judicial Court stated it, quote unquote, would bear consideration whether submission of the same evidence to multiple grand juries would be inconsistent with the purpose of grand juries to, quote unquote, shield the innocent against hasty, malicious, and oppressive public prosecutions. While it is the general rule that a court should not inquire into the adequacy or competency of the evidence upon which an indictment is based, when it appears that the integrity of the grand jury process has been impaired, a defendant may attack the validity of the indictment by way of a motion to dismiss. Although no indictment has been secured in this case, the process of seeking same bears on the analysis similarly. Improperly seeking quote-unquote evidence under the guise of later seeking an indictment impairs the process from the outset, which the courts are loath to sanction. Okay. The pertinent witness intimidation statute reads as follows. Whoever willfully, either directly or indirectly, threatens, attempts, or causes physical, emotional, or economic injury or property damage to, conveys a gift, offer, a promise of anything of value to, or misleads, intimidates, or harasses another person who is a witness or potential witness, person who is or was aware of information, records, documents, or objects that relate to a violation of a criminal criminal law or a violation of conditions of probation, parole, bail, or other court order. Judge, juror, grand juror, attorney, victim witness advocate, police officer, correction officer, federal agent, investigator, clerk, court officer, court reporter, court interpreter, probation officer, or parole officer. Person who is or was attending, or a person who had made known an intention to attend a proceeding described in this section, or family member of a person described in this section, with the intent to or with reckless disregard for the fact that it may impede, obstruct, delay, prevent, or otherwise interfere with a criminal investigation at any stage, a grand jury proceeding, a dangerousness hearing, a motion hearing, a trial, or other criminal proceeding of any type, or a parole hearing, parole violation proceeding, or probation violation proceeding, or an administrative hearing, or a probate or family court proceeding, juvenile proceeding, housing proceeding, land proceeding, clerk's hearing, court-ordered mediation, or any other civil proceeding of any type, or, punish, harm, or otherwise retaliate against any such person described in this section for such person or such person's family members. Participation in any of the proceedings described in the section shall be punished. Article 14 of the Massachusetts Constitution requires that all searches and seizures be reasonable. Searches and seizures conducted outside the scope of a valid warrant are presumed to be unreasonable and therefore unconstitutional. To be reasonable in the constitutional sense, a search conducted pursuant to a warrant must be supported by probable cause. To comport with constitutional protections. An affidavit in support of a search warrant must demonstrate probable cause to believe, one, that a particularly described offense is being, or is about to be committed, and two, that the search will produce evidence of such offense or will aid in the apprehension of a person who the applicant has probable cause to believe is committing, or is about to commit such offense. In addition, a cell phone search must be timely. The state must act within a reasonable period after seizure, else the seized material must be excluded. Roman numeral 2, the Commonwealth has no legitimate purpose for its motion and is simply attempting to continue its persecution of Karen Reed. I would have to agree. The Commonwealth lacks the necessary probable cause to support their requested search warrant because the requested search will not produce evidence of the alleged offense, nor will it aid in the apprehension of an alleged perpetrator. The basis of the Commonwealth's inquiry into Miss Reed for the offense of witness intimidation is a groundless allegation of indirect witness intimidation. This is evidenced by Trooper Tully's supporting affidavit, which only describes conclusory allegations of witness intimidation as occurring through Miss Reed's communications with Mr. Kearney. It is murky whether he believes those communications were direct or indirect, and he has no stated foundation that any communications actually are in furtherance of witness intimidation. Rather, Tully spends nearly the entire affidavit describing Kearney's alleged conduct, not Miss Reed's. The communications presented by Trooper Tully between Mr. Kearney and Miss Reed actually show the opposite of witness intimidation. She is clear that information should not be used or disclosed or disseminated. There is absolutely no evidence of Miss Reed ever urging or even suggesting to Mr. Kearney that any witness be contacted, approached, or even discussed in Mr. Kearney's reporting. Further, the Commonwealth lacks probable cause to search Miss Reed's cell phones in accordance with either of the standards in the second prong of the Estabrook test because they are already in possession of all information pertinent to the prospective allegations. Paragraphs 7 through 41 of Trooper Tully's affidavit have nothing whatsoever to do with Miss Reed and only concern Mr. Kearney. Paragraph 44 of Trooper Tully's affidavit perfectly encapsulates the reason why the search warrant is unnecessary and why the Commonwealth lacks probable cause to search Miss Reed's phones. Paragraph 44 reads, quote, Natalie described the arrangement as follows. Karen would send Natalie a message on Signal intended for Kearney. Natalie would copy and paste the message /photo/video or document into a text message to Kearney. On several occasions, Natalie would take a screenshot of the Signal messages from Karen and send Kearney the screenshot. Natalie stated she would send information to 2 phone numbers used by Kearney, end quote. Because the Commonwealth's groundless allegation seeks to suggest that Miss Reed communicated some unknown things to Mr. Kearney, and he thereafter engaged in witness intimidation, the only relevant communications would be those actually received by Mr. Kearney. For example, if a hypothetical communication was written by Miss Reed on her phone, but not passed along to Mr. Kearney, that cannot possibly be an example of witness intimidation, as the Commonwealth has not and does not allege that Miss Reed actually carried out any intimidation herself. Therefore, as all relevant communications would be those received by Mr. Kearney, and the Commonwealth is already in possession of all communications received by Mr. Kearney. In parents, the Commonwealth has searched the entirety of his phone. It is impossible that a search of Miss Reed's phone would produce any evidence that is not already in the Commonwealth's possession. Footnote 1. The same reasoning applies to the following paragraphs, and then it lists all the paragraphs. The Commonwealth has the other side of the handshake, if such exists. Therefore, the Commonwealth lacks probable cause to search Miss Reed's phones, and the Commonwealth's motion should be denied. The final paragraphs of Trooper Tully's affidavit expose what this motion and the and the Commonwealth's overall plan truly is an overbroad and persecutory fishing expedition intended to punish and harass Miss Reed. In paragraphs 96, 97, and 100, Trooper Tully states as a reason for searching Miss Reed's cell phones that the MSP needs to examine Miss Reed's location data and application usage, which is literally everything on the phone, to determine whether the phones actually belong to her. The thinly veiled excuse to rifle through the entirety of two of Miss Reed's cell phones, including all of her personal information, is absurd. Trooper Tully argued, expecting this court to take him seriously, that the police and district attorney need to review the entire contents of Miss Reed's phones, including whatever personal, private, confidential information lies within, to prove that the cell phones seized from Miss Reed's possession in Miss Reed's own home are in fact hers. The same cell phones that Miss Reed's counsel have demanded to be returned to her as the rightful possessor. That the Commonwealth would actually present such an argument as justification to root through her personal data speaks volumes about the true intentions of the prosecutor and investigator behind its motion. Roman numeral 3. The Commonwealth's request is untimely, and therefore the information sought cannot be admitted. As we learned extremely recently in Commonwealth v. Diaz, the Commonwealth may not seize its cell phone and indefinitely deprive its owner of their possessory interest before seeking a search warrant. The police may retain an item seized without a warrant for the relatively short period of time needed to obtain a search warrant, but must release the item if a warrant is not obtained within that period. That's what I've been saying all along. If the police failed to obtain a search warrant within a reasonable time, the seizure, even if it was sorry about this, guys. This is kind of a pain in the ass. I'm going to have to figure something out next time. Even if it was, quote-unquote, reasonable at its inception because it was based upon probable cause, may become unreasonable as a result of its duration. When officers fail to seek a search warrant, at some point the delay becomes unreasonable and is actionable under the Fourth Amendment. The Commonwealth bears the burden of demonstrating that the delay was reasonable. The Diaz court held that individuals have a critical possessory interest in their cell phones. We first note that the defendant had a material possessory interest in his cell phone at 18. Many who own a cell phone in effect to keep on their person a digital record of nearly every aspect of their lives. The Massachusetts Appeal Court, less than 1 month ago, held that a delay of 123 days between the seizure of a suspect's cell phone and the first time the Commonwealth seeks a warrant to search it is unreasonable. The judge ultimately concluded, based on these findings, that there is no legal precedent for finding a delay of 123 days to be reasonable. And they've had hers for how long? Even with a compelling governmental interest. That conclusion is, to date, correct under Massachusetts law. The court further opined that, quote, our courts have recognized that some delay in obtaining a search warrant may be reasonable, whereas here the governmental interest is the seized item is critical, end quote. But there is no Massachusetts precedent upholding as reasonable in this anything remotely approaching the 123-day delay in the present case. Wow. Many pages is, but I don't know if I can do this much longer the way it's going to take forever. Quote, reasonable at its inception because it was based upon probable cause may become unreasonable as a result of its duration. Did I already read this part? I think I did. Yep. God damn it, how'd that happen? So that's page... Oh, man. Why does this keep giving me the same page? It's weird. Here, the Massachusetts State Police seized Miss Reed's phone on January 24, 2024, and did not seek a search warrant to search its contents until August 28, 2025. This is a gap of 582 days, nearly 5 times longer than the 123 days that the Diaz court held to be an unreasonably long time. The law is perfectly clear. The Commonwealth's request is well beyond untimely, and therefore the evidence sought must be suppressed. They forgot their T. I'm a grammar Nazi, sorry. Conclusion. Miss Reed's phones were seized on January 24, 2024. No action was taken on the allegations of witness intimidation until a year and a half later, when the Commonwealth penned this motion. Conveniently, the motion only came to fruition after Miss Reed requested that her personal property be returned. Only then did the special prosecutor indicate an intention to rummage through her cell phones in the first instance. The Commonwealth cannot claim that they were merely waiting for Miss Reed's trial to conclude before pursuing this action, because they attempted to indict her before a grand jury while her first trial was pending. For the above reasons, and for those argued by defense counsel at the hearing of this motion, Ms. Reed respectfully requests that this honorable court deny the Commonwealth's motion and order Ms. Reed's personal property to be returned forthwith. Respectfully. Phew, I didn't think we were going to get through that. So, there you have it. About 2 hours, so not too bad. I want to thank you all for joining me, and I want to thank you all for your patience while I iron some of the things out that weren't really working for me. I am getting a little bit better at this. I hope you agree. And I hope to see you again soon. I will keep my eyes posted for any updates as far as the Mimi Torres case goes. Her mom and aunt and her mom's boyfriend are all due in court this month. I believe the mom is due December 12th, the aunt is December 16th, and the ex-boyfriend is December 19th for pretrials. They've all pled not guilty, of course. And I believe Aaron Spencer's case starts in January. I don't think he has any upcoming pretrial. And we're waiting to hear from the SJC in the Kelsey Fitzsimmons case. She had a hearing on Friday. That judge seemed like a real peach. Let's just say that. I don't know. He kind of has a bit of an attitude, and he has a hard time listening. He likes to hear himself talk, so it's hard to know if he's just ornery or if he doesn't like Bradel. But Bradel held himself very good, very well, I think, and he stood through the whole thing, and I just feel for him. How can anybody be mean to Tim Bradel? You know, he's the biggest sweetheart there is. But anyway, Kelsey looked healthy. She seems to be in good spirits. Everybody keep praying for her and keep writing her and keep her family and Kelsey in your prayers, as well as Aaron Spencer, his family, his daughters, Aidan Kearney. He needs our prayers too. He's facing a lot of years in prison. People that say that he's not are full of shit. I don't know why nobody wants to take it seriously. He's facing basically life in prison. Just because it's not murder or something like that doesn't mean it's not a serious allegation and a serious charge. He's facing basically life in prison, and that's scary. He has every right to be acting out, and yet he's not. He's acting like a perfect gentleman to you know who, and that says a lot because he has every reason to be a complete prick as far as I'm concerned, and he's handling it all very well, better than I ever would. So kudos to him. And that's about it. So I will let you guys all go, and I appreciate you tuning in. Take care, be safe, and have a good night. Thanks. Bye.